Good day to each and everyone. I am Shella Tisabar from Group 5 and I am the fourth reporter in our group. So our topic is about the employee management in Chapter 12. So let's start. Learning from employee turnover. So employee turnover refers to the numbers of workers who live in a company in such a period of time. So when it is necessary to let an employee go, do so with dignity and fairness, professionalism and compassion. So of course, if it is really necessary to let an employee go, we should, as a manager or as a supervisor, you should do with you should do the procedure with dignity and fairness. So dapat patas siya, tapos professionalism and compassion. So the deed should be preceded by a predictable system of communication, documentation, and support, such that the firing consists of a brief conversation that does not come as with a complete surprise to the employee, and it is the opinion of some human resource. So, as I have said, the deed should be preceded by a predictable system of communication. So, dapat you should explain about the necessary firing or to let an employee go. And then you should also you should conduct a meeting or an agenda about that, so that persons or workers will not be a complete surprise. Of course, they should be aware about that. So it is tough to put the blame entirely on an underperforming employee who has not given the proper instructions, tools, and consistent feedback to do the job well. So of course, lisod gayud siya na ato i-blame an workers kung kita mismo na supervisors or managers where nato sila tagaanan sakto na instructions and kagamitan og uno pa ng mga dapat buhaton na nato mga workers para matapos ang trabaho nila in proper way. Keeping good documentation is essential even when you hired well and trained thoroughly. Not everyone in the hospitality industry stays forever. So of course, waray sa gayud forever, especially sa hospitality industry, bisan palang pa. Even you were hired and well trained, so waray gayud forever sa trabaho. Yay gayud kasagaran matanggal or muhawa. Amo gayud siya ang reasons, or isa sa mga reasons. In the Consultants magazine, Bill Main suggests that managers should find out why employees leave by conducting exit interview with them, including the few simple questions listed in figure 12.9. So, gasuggest daw ang Consultants magazine na si Bill Main na of course, dapat as a managers or supervisors, you should conduct exit interview with your workers. So, makita yon siya sa figure 12.9. Yadton simple questions na para sa exit interview ng mga workers na gusto mo hawa or gusto nila maundang. And then, labor and employment laws. As employer in any field, they are well aware on today's work relationships are fraught with potential legal risk, minor misunderstanding between workers that are settled informally for alleged errors, injuries, pay disputes, and discrimination. So generally, frontline managers or supervisors receive little or no training about how to handle remarks or simple decision might be. So sa labor and employment laws, so sa ato gayud field nan as managers or employers, so aware gad kita nan mga patakaran ko man kasagaran niya yung mga discrimination, yung dili misunderstanding, wala pagkasinabot sa workers o employers na amayon makasingod na yaw usahay kasagaran problema sa your relationship as an organization. So generally daw, dapat ang frontline managers or supervisors, so kung ning ana manggaling ang situation, kasagaran wara kibali supervisors receive little or no training about how to handle remarks. So kasagaran paging ana na situation bali kuan na serious na kadayaw. So kasagaran sa guding ana ng mga managers wala sila maka training o kon unhon pag-handle ng remarks na mga situation kanaman or bisan mga simple na decision. So kanaman dili dayon mahibawan kun unoy solution dito na issues. Some employers are so concerned about the remarks of a lawsuit that they refuse to make difficult decisions which result in reduced productivity, sagging morale, and inadequate communication with their workforce. So, yaoy kasagaran isa some employers na concerned gid sila sa mga batas or mga policy about sa labor and employment laws na so because of that medyo maglisod sila paghimo ng decision para na amoy makasingod na medyo makuha ng ila lang pakalambuan. Kay of course, kung amoy on may makasupak sa mga balaod, mugamay ang ila mga kuan productivity tapos ang ila communication sa workforce dili sila magkasinabot. Dili nila masabutan kung ano ang nila planuhon for that situation. When allegations are serious, as an individual managers or supervisor should be trained to spot potential problems and act on ways that reduce their employees' exposure to legal action. So, B&A Communications Incorporation of Rockville, Maryland, is a company that conducts corporate training for managers, has created 10 rules for workplace liability. So, kung ang mga situation or allegations daw is very serious, so dapat daw ang individual managers or supervisors should dapat gayud naka-training or should be trained. Dapat ilayon gitrainingan kung unhon pag-handle ng mga potential problems and dapat aksyonan nila ang mga problema ng ila mga aksyonan nila ang problema sa ila organization para dili sila magka-misunderstanding. So ang B&A Communications Incorporations daw ng Rockville, Maryland. So, gahimo sila ng training for manners. Conduct corporate trainings for managers. So, gahimo sila ng 10 rules para sa workplace liability. Amay ni kasagaran an ilagi. Amay ning gihimo nila ng 10 kabuok rules sa ila mga trabahoan. Rule number 1, watch what you say. So, of course, as a manager or supervisor, you should watch what you say. So, dapat gayud bantayan nato kung unay imo mahi-istorya or mahigawas sa imo baba. So, don't make threats. Amoy nin pinakauna, dili ka dapat maghimo nan panghulga. So, managers will make a casual comment that seems threatening employee who is trying to take advantage on those rights that are protected by law. So amoy on siya dapat as a managers dili ka pwede maghimo ng comment or casual comment na makahulga sa imo mga workers about sa iyo workplace na mag-take advantage ka sa karapatan nan bawat workers nimo na under na niadton law. Don't make promises. So during tense situation that can hurt the organization. So dili ka dapat as a managers or supervisors, you should not make any promises, especially during the tense situation. Kay usahay sa god as a managers usahay makahimo-himo kita ng promise na para dalang ini ma-solve, pero usahay wala ka kasad sa imo promise, wala nimo yadto mahimo, so that organization can be hurt with your promises. Don't denigrate. Never make any comments on or off the job that can be demeaning to a person's age, sex, race, religion, national origin, or disability. So, of course, don't denigrate. So, dapat dili ka guide mag-comment whether on or off the job. Kung yaon ka sa trabaho or wala ka sa trabaho, dapat dili ka pwede mag-comment ng mga sakit na mga istorya na ma-misinterpret ng mga tao, especially through their age, sa ila edad, 6 kasarian, and then race sa ila status sa kinabuhi, and then religion and national origin of disability. So dili mo dapat sila pasakitan ng mga istorya kay syempre lain-lain sa kitaya sa sensitive na mga tao. Don't ask improper questions. Example here is by inquiring about the applicant's medical condition in a pre-employment interview because you might violating the Americans with Disabilities Act. So, nga din side is dapat dili ka gayud basta-basta magbuhi nan questions, especially kung about yaton imo applicants is persons with disability kay ma-violate mo ang ila feelings or you were violating the Americans with Disabilities Act. So may balaod ng about ninyon kay by the way this is iniagaw na mga kuan laws is kasagaran sa Amerika ini na nakapasar. So sa ila da ini wala sa ini gamay da sa niyaon sa ato bagan nga di. Rule number 2, keep accurate records of hours worked. So, dapat kada gayud oras nagatrabaho ang imo workers, imo gadyaon siya ilista or imo i-record kay para dili bitaw sila masayang or dili sila magmahay sa ilang mga kuan. Example here is when employees ask to work after hours without recording this. So, of course, kung ang imo employee imo patrabaho na kuan na o lapas na sa oras, magmahay gid yun sila kung dili mo yun to i-record as overtime. Rule number 3, be sensitive on implications of sexual harassment. So, of course, dapat sensitive ka sa pag-implikar, sa pagpatupad ng sexual harassment as a supervisor. You must understand that their words can be taken out of context and can use against them with jury's trial. So, dapat sensitive ka sa imong mga words na imo buhian or sa imong istorya sa imong mga workers. Especially, ang sexual harassment kay dali daraba, especially sa mga babae. Kasagaran gayud ini mga sensitive babae or mga labi na sa mga idada na or mga dalaga. So, dapat dili mo sila basta-basta iharas ng istorya. Especially kung magtiyab-tiyab kay usahay sa god. Magamit ini siya na mga words against you kung magkakaso-kaso man galing. So, rule number 4, document everything. It's a smart business practice for supervisors' memory of a discussion or incidents, especially in the absence of related documentation. So, of course, that documentation serves as evidence in court jury's trials. So, document everything. Dapat gayud dokumentado ang tanan. Nakalista, naka-record. Kay isa yon sa smart business practice para sa mga supervisors. So, dapat imo gayud naka-document gayud ang mga discussions or panghitabo sa iyo workplaces. Para in case of magka-problema or maglaong pa maabot manggaling sa korte, at least may evidence rather. You have an evidence in the court trials to use. So, rule number 5, be consistent. So, the supervisor's characteristic must treated the same behaviors with the different employees. Example here is person with disability or based on their sex for doing their job. So, of course, understandable sa guide yaon na dapat as supervisors, we should be consistent. Dili lamang patas nato sila ba itrato. Especially kung ang imo worker is may kapansanan or babae. So, dapat itrato nato sila kay dapat patas para fair. Rule number 6, be safety conscious. So, understandable sa ini nga day. The Occupational Safety and Health Administration requires employees to document all work-related injuries that require medical attention. So, dapat gayud ang mga employees na yung kinahanglanan mga medical attention, dapat dokumentanan, especially itong mga employees na nagkinahanglan ng mga medical attention. So, importante yaon sa workplace na safety conscious guide ang supervisors or managers. Rule number 7, seek outside help when unusual circumstances arise. So, dapat mangayo ka guide ng tabang, especially sa mga serious na mga sitwasyon. Like for example, sa mga When supervisors encounters difficulty, he or she should seek for professional advice immediately. So in case na mga may moabot na mga panhitabo na dili na wala nimo unexpected nimo or dili na nimo control, so dapat mga ikaw ng advice sa mga professional, like for example sa mga attorney kung ang situation is kaso-kaso man galing. Rule number 8, consider all implications of any special request. Example here is a simple request for leave, which is a long period of time of work. So dapat kahibaw ka mo consider nan tanan mga implications sa mga special request. So especially sa kung kibali may sakit ang imo worker, dapat kahibaw ka mo consider na tagaan mo sila ng leave or karapatan mag-leave, especially sa mga pregnant workers or may mga sakit nagibati sa lawas. Rule number 9, take seriously all situation in which termination is implicated or threatened. When employees threaten to quit, take them seriously and immediately report this to your superior or to your company's human resource department. So in case na ang situation, dapat gayod, imo gayud i-take seriously ang tanan mga situation, especially sa pag kung may mga kinahanglan tanggalon or yaon mga nabalaka kibali sa i-workplace. So dapat imo gadyon siya i-report sa imo superior na nakatataas sa imo or sa imo company's human resource department kay sila ang mag-handle nan ngadto kung unhon pag solbad nan situation. So last one is rule number 10, be aware of laws. Take an opportunity to familiarize yourself with these laws as well as to gain fuller understanding of how they might impact your daily decision as a man of acre. So example here is seminars. So of course, dapat as supervisor or manager, dapat imo gayud i-take an opportunity na ma-familiarize mo sa imo kaugalingon ang mga laws na dapat i-apply, especially sa imo organization. Example here is seminars. So dapat mag-appeal ka ng mga seminars para ka ma-aware sa mga laws or balaod ng mga balaod na gipatupad, especially sa mga ato gihisgutan nga di sa employees laws. So applying this knowledge in the job will save you and your organization time, money, and aggravation. So if ma-familiarize mo na ito na law, so pag ma-apply mo na ini na knowledge sa imo as a supervisors or managers, of course, ma-save an imo organization and ma-save pa ang imo oras, an imo money, and an imo mga plano. Laong pa, mulambo pa. So let's move here an overview of labor and employment laws. The following is a brief summary of the major federal labor and employment laws, those most frequently implicated in court actions. Remember, these are only the U.S. federal laws. Many states have passed their own similar legislations about this topic that in some cases is more restrictive. So, ini daw na mga laws is mostly naka-implicate sa mga korte or pasado na ini siya na mga balaod. Pero ngadto da sa US ini, wala ini bagan sa ato. Wala sa ato. So, an important note, these summary capsules are not a substitute for legal advice, which should always be sought from an attorney familiar with employment issues. So, importante guide ini is ini na summary dapat dili ini basta-basta, dapat gayud mo dool ka na sa mga attorney na naka familiar na about inin mga kaso or balaod. Americans with Disability Act. So this is a law or this act prohibits discrimination against disabled applicants in privately owned companies with 15 or more employees. Employers are required to make a reasonable accommodation to allow an otherwise qualified disabled person to work unless making the accommodation would cause undue hardship to the employer. So in 2009, the ADA or Americans with Disability Act was amended to explain the definition of disability in individual cases such as the condition of asthma, high blood pressure, or disease or chronic condition that is in remission might also constitute a disability. And the Equal Employment Opportunity Commission, or EEOC, is the responsible for enforcing this act. So this kind of law is for disabled person or persons with disability. Especially kung yaon sila sa trabaho or nang-apply sila or sa workplace. So, para ini sa ila ng mga laws na dapat tagaan ta sila ng chance, especially kung kaya pa nila yadto na work na dili sa makakos nan kalisod sa employer. Kay yay sa disabled persons na kaya pa nila mo trabaho. Like for example, yaoy iban na waray sike pero maka-wheelchair sa sila, so makalihok an ila kamot pag-type or pag-computer. Og damo pa ng mga example sa og iban pa ng mga persons with disability. So ang nag-enforce nan ini na law is the Equal Employment Opportunity Commission. Amo ini nagpatupad in year 2009. Especially yadton may mga sakit na asthma, high blood pressure og iban pa na dili kadayo serious na pwede pa sila makatrabaho. So dapat tagaan sila ng karapatan or reasonable accommodation para makatrabaho sa isa ka workplace. Next, Age Discrimination in Employment Act of 1967. So this law states that company with more than 20 employees may not discriminate against worker or job applicants who are over 40 years of age. The EEOC is responsible for enforcing this act. So, ang Age Discrimination is in Employment Act of 1967 is gihimo ini siya para dili pwede na discriminate ang mga trabahante or mga job applicants na ang nag-edad na nan 40 years old. So dili na to siya dili sa ila lugar or sa Amerika dili basta-basta nimo na ma-discriminate ang mga gaedad dan 40 years na trabahante or nang-apply pa kay may balaod ngadto. Pwede ka madaot charot sa ila dayon. Equal Pay Act of 1963. So this act requires equal pay for jobs that are substantially equal in skills, effort, and responsibility, and thus performed under similar working conditions in the same workplace. This act is primarily designed to sex discrimination in payments and wages, salaries, and other forms of compensation. This act applies to private employers and all government employees too. So of course, the EEOC also was the responsible who enforced this act. So masabot sagad nato ang Equal Pay Act. So dapat patas ang sahod or ang wage rate sa ila sa Amerika. So or sa gawa sa US kuno. Equal dapat ang pagbayad sa mga tao, especially kung parehas da ng skills, effort, responsibility sa ila workplace. So this act also is designed gihimo para sa sex discrimination, especially pag ang iban sagod na mga lugar kay pag babae murag dili nila ipatas ang sweldo. Pero ngadto sa ila patas kay bisan babae man kaw or lalaki. Basta lamang mahimo mo ani mo trabaho. So sakto gad nila bayad, patas. Immigration Reform and Control Act. This act prohibits discrimination against people for their national origin, citizenship, or intended citizenship. So, Immigration Reform and Control Act, gihimo ini para malikayan ang pag-discriminate sa nationality ng mga tao sa ila sa ila citizenship, especially kung negro ka or example dayon ko negra ka or Pinay, di ba yay sagod kasagaran iban yon ila i-discriminate sang leta raw kay dili kibali ang mga hawd sa ato usahay, di ba ato i-discriminate ang mga dili kun ako ha charo yay mga negra manaway bitaw kita ato sila i-discriminate, so sa ila bawal kay diyon dili basta-basta sa ila citizenship, so dili ka makabuot kun unay ila kay laong pa may balaod nga na. This act, next is Title 7 Civil Rights Act of 1964. This act says that employers may not discriminate against worker or applicant on the basis of their race, skin, color, national origin, or sex. So, parehas, murag, kuan da isab ini sila, same da isab sa kuan, na dili nimo basta-basta ma-discriminate gihapon. Ay, amo ba inin ako i-explain kay na dili ba pwede sila ma-discriminate ang mga workers as or applicants kung na magbase ka sa ila palis or sa color ng ila lawas lang pa di negra or sa ila kasarian kung bayot bakla tumboy dili sila mag kuan kay tanan sa ila may civil rights. So this act is a far-reaching act which applies to all companies and all forms of government. Unlawful discrimination includes over or disparate treatment, disparate impact treatment, sexual or racial harassment, and retaliation. So as I have said, dili mo sila pwede ma-discriminate kay this law is para gi-apply sa tanan mga company ng government. So ilagay din gipa implikar especially sa mga discrimination and over or disparate treatment sa mga applicants or workers and sexual or racial harassment. In 2009, the GINA law or the Genetic Information Non-Discrimination Act is an act to prevent discrimination for health insurance. So the GINA daw is the law for non-discrimination about the health insurance. Balaod yon siya na dili ka pwede mag-discriminate kung ang tao is may health issues. So Title 7, Sexual Harassment. We are all familiar of this law. This act applies not only to supervisors and managers but also to employees. This type of harassment includes unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. So familiar sa kita, aware sa kita sa sexual harassment. So yay sagod kasagaran mga supervisors o managers na abusado. So usahay sila mag-request raw sila ng kuan, usahay mga dili na angay ipabuhat sa ila workers or sa ila staff, especially kung usahay apil na ang mga sexual nature. Di ba kasagaran usahay paglalaki an worker usahay manguan mag-abusar sa mga babae. Damo pa yon sila na klase kay bali. Example dito. So next, National Labor Relations Acts. This act gives employee the right to form, join, or assist labor unions and to bargain collectively through representative of their own choosing. It is also known as Wagner Act, passed in 1930s, which was amended by the Taft-Hartley Act in 1940s. So the National Labor Relations Act is balaw din siya na an employees or trabahante pwede mo appeal or pwede maka-assist sa labor union sa pamamagitan ng ila kaugalingon na kagustuhan. So this act prohibits from interfering with, restraining, or coercing employees as they exercise their collective bargaining rights. Example here is if the companies cannot donate to union or interfere with their operation, can't encourage or discourage union membership. So this act also dili pwede sila na mo interfere sa mga operations ng mga employees. So dili sab pwede sila na ang company sab dili sab pwede na mo donate or mo makialam sa mga operations ng iya employee. O dili sab pwede na i-encourage or i-discourage ang membership union. Fair Labor Standard Act. This act is covered in detail in the next section, which is the compensation and benefits. So, Family and Medical Act of 1993, a company with more than 50 workers must permit them to take leave for up to 12 weeks unpaid for family or medical reasons. This act also specified the number of hours and years an employee must work to become eligible for this coverage. So, ini siya ang Family and Medical Act of 1993 is para ini sa mga company na may mga 50 na mga workers. So, dapat ila initagaanan permit na maka-leave ng bisan 2 weeks. Syempre, unpaid yun siya for mga family or medical reasons. So, dapat trabahanti ka gayud nan or dugay na kagayud na trabahanti na sa imo company na gitrabahoan para mahimo ka nan eligible o makaver ka nan ini na act. So, Employee Polygraph Protection Act. So this act is private employers cannot administer or require polygraph or lie detector test either to job seekers or current employees, except under circumstances. This act enforced by the U.S. Department of Labor. So the Employee Polygraph Protection Act is para sa mga private employers na dili sila pwede maka-require ng polygraph or lie detector tests. So may mga technology bagan ini siya na na nasagol sa ila workplace. So this act is enforced by the US Department of Labor. So Occupational Safety and Health Act. So this act prohibits employer who are engaged in interstate commerce from requiring their workers to perform tasks in unsafe places or unsafe manners. So this act is ginabawal ini sa mga employers na kibali ang ila workers is ipa-perform ng employer sa ila employee ang mga task na dili safety sa lugar o dili safety ang mga buluhaton or trabaho. This act also requires employers to keep various types of records about the job safety and accidents and prohibits employers from retaliating against workers who bring health or safety related claims against them. So this act is also requires employer or for those or managers or supervisors na dapat i-record gad nila ang mga accidents sa ila workplace, sa ila mga workers, especially sa yadton mga nanginahanglanan health and safety na mga medical attention. Compensation and benefits. So this act is an employer may pay the members of a staff using several different methods, especially if some of them receive additional income in the form of tips. The compensation picture is often made more complex by overtime pay, bonuses, commissions, and incentive pay. So in compensation and benefits kibali mga kabayaran kibali og mga benepisyo sa imo pagtrabaho. So inikibali siya is covered. Ang covered na nini is pwede siya ang employer magbayad ng membership ng staff sa kibali lain-lain na way. Like for example, sa overtime pay, bonus o iban pa na commission and incentive pay. Methods of compensation and rates of pay. So these are the methods. Bar personnel are usually paid by one of two methods. So hourly wages or a fixed salary. Tips add substantially to the earning of bartenders and cocktail servers, while a supervisors or beverage director receive a monthly bonus. Pay is also the type of ownership with sole proprietor, generally paying lower wages than partnership and corporation. So these methods, like for example, a bar personnel, kasagaran siya is ginaswelduhan in two methods. The hourly wages or a fixed salary. So may inuras na sahod or naka-fix na guide siya na bayad or sweldo. Ang mga tips, syempre, additional na ito sa ila mga earnings, sa ila kita as a bar personnel or bartender servers. So while ang supervisor daw or beverage director maka-receive ng monthly bonus. So pay is also the type of ownership. So pwede sila mabayaran in their ang bayad daw is also the type of ownership with sole proprietor, generally paying lower wages. So depende siguro ang bayad is depende sa supervisor or beverage director kung kibali sabutan nila ang bayad kung kaltasan ba sa ownership or partnership and corporation. Federal minimum wage requirements is when you begin to determine what you will pay employees, you can use federal and state minimum wage laws as a base, and the federal wage was created in 1938. And in 1990, the FLSA or Federal Fair Labor Standard Act was amended a lower submission wage or called a youth minimum wage. So gamay-gamay da siya an rate ng sahod or salary. Where the federal submission wage applies, employers are prohibited from getting rid of full-time workers or cutting their hours to hire lower-paid newcomers, and also illegal to hire underage to 20 for 90 days. So bawal ini daw siya na federal minimum wage requirements is bawal sila mo hire ng 20 ang age under for 90 days. So 3 months yon siya bawal sila mag-hire ng mga kibali underage sa ila. Sa ato is 18 sang underage, 18 below. O 17 below. Yan. So wage may also apply to full-time students in the workplace, some apprentice and trainee jobs, and individual whose productivity is limited by physical or mental disability. So inisab siya na requirements, pwede siya ma-apply sa mga full-time students. Like sa mga may gat-trainee ng trabaho o sa mga individual na ang ila productivity is limited. Kibali lang pa abtik mo trabaho bisan may ila mental or physical disability. Defining the work week. So a work week is defined as a fixed and regularly recurring period of 168 hours, 7 consecutive 24-hour periods beginning any day of the week at any hour of the day. So a work week daw is a fixed or regular na period na nagtrabaho kibali ang workers within 168 hours. And 24 hours period. So, kompleto naka-fix na siya na regular na trabahante. Example, an employee is paid weekly. So, naka-base, example here is ang worker or ang staff is, ang iya sahod is weekly or monthly. Employees must be paid for all hours that they work in any work week, including breaks or rest period from 5 to 20 minutes that occur within their work time in the terms of computing minimum wages and overtime payments. You do not have to pay for a meal period for lunch break. Also, if lunch involves any work or duties while employees eats, you must pay them for that time too. So kasagaran mga trabahante is ginabayaran sa every week including ang breaks or rest period. So bayad yon siya, syempre rest time. Gi-compute na kibali yon siya sa minimum wage and overtime payments. So as an employer, dili mo kinahanglan bayaran ang ila meal period or lunch break kay syempre pahuway sayon sila. Pero if may imo impahimo sa iya na trabaho while gakaon siya, so dapat bayaran mo gihapon ngadto siya sa imo. So sa imo mga task nga gipahimo sa iya kay lunch break sa garon niya pero may imo gipahimo. So that is the example for the work week. Tip pooling. So tip pooling is the employer cannot claim any part of the tip money for the business but may require tip pooling. So kasagaran sa good sa bars is manghatag ng tip. So yaay sa mga employer na murag kuha yon imbis na tip para sa ila servers or bartenders, ginabira kibalin ng employer. So servers or bartenders tip out or share a percentage of their tips with barbacks, busboys, and other service staff who have the direct contact with guests. So depende sa biyay kuno servers or bartenders na ang ila tip is ginabahin nila para fair, especially sa ilang mga kaiban sa barbacks. So sa busboy o sa staff na amoy may direct contact sa guests. So in some cases, such as large parties, there is a policy at many bars or restaurant adding a compulsory service charges of 15 to 20% to the bill, and this charge considered as the tip, and it is defined by FLSA as part of the employer's gross receipt. So there is a policy at many bars of a restaurant. So nag-add sila ng 15 to 20% sa ila bill sa customer nila, and that serve as the tip of the server or bartenders because it is written in the FLSA as part of the employer's gross receipt. So nakabase to siya sa FLSA na law. Other charges. So in some of the companies gina-require nila is bayaran or libre ang uniform. So, uniform for both bartenders and servers that charge to employees. Oo, amayon siya. Employers cannot deduct from paycheck occurrences as breakage of glassware or shortage in the day's cash register receipt. So, ang employers daw, dili pwede nila i-deduct anyadton paycheck ng ila workers kung makabasag sila ng mga baso or kagamitan or ma-short ang days ng cash register receipt. Kay syempre, amoy kuan sa ila, amoy nakabalaod na dili nila pwede basta-basta i-deduct. It is important for both workers and supervisors to keep accurate written records of all these factors to ensure that everybody gets paid and no one feels cheated. So, importante for both workers and supervisors daw na dapat nagahimo sila ng accurate written records. Ginalista nila ang tanan mga panghitabo to ensure that tanan is paid and waray waray maka-feel na gi-cheat sila or gilimbungan para patas. Supervisors as exempt employees. So, the FLSA exempt supervisors, managers, administrators, and executives from minimum wages requirements are called exempt employees, while this covered by the act called non-exempt employees. So, these are the three of the following tests must be met to the employees to be exempted from overtime pay. So, number one is the salary basis test. Employee must receive a predetermined fixed salary amount for every day period that the employees work. So, dapat daw, ang pinakauna is the salary basis test. So, dapat ang imusahod is naka-fix guide siya sa amount na pang-adlaw for the day period. So, the second one is the salary level test. So, the employee must make at least $455 a week or for an annual salary of a total of $23,000 to be considered as exempt employee. And dapat, so, of course, dapat daw, ang imo salary is mag-equivalent nan tag $455 per week. So, equivalent to $23,000. The third or the last one is the duties test. The employees must perform the job that most involves in executive and administrative. So, an executive is the person's primary duty is to manage recognized departments, or he or she regularly direct the works of two or more other employees. So, dapat that person is capable of doing a regular direct on how to manage a recognized departments. So, o kaya sab niya buhaton ang trabahoon ng two or more other employees. So, the other one is in administrative, dapat is the person is to perform office or non-manual labor that directly related to the management or general business operations of the employers, and exercise discretion and independent judgment and professionalism are broke down into categories. So, in administrative daw, there is two categories na dapat niya i-perform as an administrative. So, dapat kabalo siya mo manage ng mga general business operations of the employers, and independent siya on how to judge or judgment, and a professionalism. So the two categories are letter A, creative professionals, and letter B, learned professionals. So in creative professionals, including the culinary arts, creating or designing a unique menu item. So as to become an exempt employees, dapat you must be creative professionals. So you must have the knowledge in culinary arts and creating or designing a unique menu items. And then learned professionals. So you must attend have attend a 4 specialized academic degree. So dapat naka-attend ka ng 4 years specialized academic degree for that specific professionalisms. So that would be all about my report. Thank you and God bless.